Welcome to CareSmartz360 On Air, a home care podcast. I'm Dennis Gill, a senior sales consultant at CareSmartz. Get ready, listeners, because today's guest is not your average attorney. Meet Robert Markette, the legal lifeline for home health, hospice, and private duty home care providers. Robert is, of course, counsel at Hellrender, where he's not just dabbling in the details, he's diving headfirst into the deep end of Medicare, Medicaid, HIPAA, and everything in between. So, from navigating complex fraud, abuse laws, to wrangling with wage and hour issues, Robert is the legal pro the home care industry didn't know it desperately needed. So, with over 15 years in the game, he's developed a reputation for tackling every compliance twist and regulatory turn with finesse. Audits, check employment policies, you bet. Government investigations, bring it on. Whether he's defending clients in court or helping them breeze through an audit, Robert's mission is clear: to keep home care providers on the right side of the law while they focus on caring for others. Let's get right to it. Welcome to the podcast, Robert.
Thanks for having me. That's a very kind introduction.
No, we're really glad. We're really glad that you were able to take out some time for our listeners, and it would be really helpful for them to go through this topic today. Right. So I'll straight away deep dive with our questions. The first question that we have for you is that what are the primary types of state and federal audits that home care agencies should anticipate, and how do the focuses differ?
So the primary federal audits are obviously Medicare, whether it's a SMRC, a UPIC, the MAC. They come probably looking to take money back. At the state level, similar, you'll have Medicaid auditors, Medicaid RACs, things like that. The focuses can be a little different. Most of them, like the SMRC, which is a medical review contractor at the federal level, the MAC, the Medicare Administrative Contractors, and most Medicaid auditors, although the programs vary from state to state with Medicaid, are looking at overpayments. They're looking to see, does your documentation comply with the documentation requirements for the various payment programs? So for home health, do you have your face-to-face documentation, stuff like that? If it doesn't, they're going to take the money back. The UPICs are a little different because they are a uniform program integrity, so they're looking at fraud. They generally are going to come to you on a referral or some reason they think there's fraud going on. Their audit focus will be similar in terms of looking at documentation, things of that nature. Does the documentation meet the requirements? And then over broadly, does the documentation support eligibility, et cetera? And all the providers will look at that in eligibility. But with the UPIC, because it's a fraud investigation, that means somebody thinks you're doing something wrong intentionally, possibly. They may have gotten a tip from somebody. Sometimes UPIC audits will come because somebody called the Medicare hotline. Medicare don't investigate. They hand it off to the UPIC. So the UPIC's a little bit different. If you get a UPIC audit, you're going to want to consider, maybe a duty counsel. And the other thing with UPICs is they are far more likely to extrapolate, which means they do the audit of a sample, and they say, okay, well, in this sample, your error rate was X%. We're then going to take that percentage, and we're going to go back, and then the sample covered a time frame, usually a year or two. We're going to look at the total amount of money Medicare paid you in that time frame, multiply it by the error rate, and that's what they're going to demand back. And so that can be, I had a case once, it was about a $60,000 audit that when they extrapolated became $2.4 million.
Oh my God.
Which is crazy.
Yeah.
And the other thing they can do is they can say, hey, we've done this audit. We think there's problems. We want to keep investigating. So we are going to suspend your Medicare payments while we continue to investigate. And you have the right, if they do that, to submit a letter saying, hey, guys, can you rethink this? It's not a formal appeal. You don't get to go to an ALJ. It's just a letter that you can write asking for them to reconsider suspending your payments. In my experience, they don't. And then that means your payments will be suspended while the investigation continues. And that can continue for 6 months, and they can extend it beyond that if they want. So when a UPIC shows up, things can get a lot more painful.
Definitely, it can.
So those are kind of the audits you could possibly be facing as a home care provider.
Okay. And what are the top compliance areas agencies should monitor regularly to stay audit ready, or particularly regarding Medicaid and HIPAA?
So from a compliance perspective, On the audit side, there's obviously several issues that are big in terms of eligibility. You can actually get data, the max published data every quarter or so, showing the top audit error rates. One that's of interest from a compliance standpoint is, at least for Palmetto's data, a significant percentage of providers have audit outcomes that are negative because they just didn't respond.
Mhm.
Palmetto, last time I looked, was looking at 40% of their audit requests just didn't get a response. So one is, from an audit perspective, when the letter comes in, when you get an ADR request, do you have the components and pieces in place to respond? Are you prepared to get the documents together, accept it, request an extension of the deadline and things like that to get the documents out the door? So you at least get to the second level, which is when they audit you, and maybe you don't lose everything. So that's a big one. Obviously, for audits for home health, it's face to face is a big one they look at. Homebound status. Um, on the hospice side, you get terminal illness eligibility. They're always looking at eligibility, whether it's home health, hospice.
Okay.
You get the same thing with waiver. They can look at eligibility and just should the patient have been there, but and does the documentation show the services provided? HIPAA, the biggest thing you're seeing there. So HIPAA is more complaint driven than investigation driven. So when you get a complaint and the government comes up, the most common thing you see agencies, and not just agencies, but providers across the board, from hospitals to physician providers, get cited for in HIPAA is a failure to do a HIPAA risk assessment. So one of the components of the security rule is that you've performed a risk assessment to analyze, where are your weaknesses, things you need to fix, and that should be done on a recurring basis. A lot of home health and hospice providers and home care, we did that at the beginning, back when HIPAA came online 15 years ago, and haven't revisited it. Well, what we're seeing now is when OCR gets a complaint and comes out, one thing they ask to see is your risk assessment. And if you haven't done a recent risk assessment, they're really hammering folks, imposing fines and penalties for not doing that risk assessment, because what the Office of Civil Rights thinks is if you haven't done the risk assessment, you can't possibly be in compliance from a HIPAA standpoint. So that's a big one with HIPAA. Obviously, also with HIPAA, you want to be cognizant of patient rights and making sure you're granting patients access. If you're a home health agency, remember the Medicare home health COPs give you a much shorter window to respond to requests for access. Another one that I've seen a lot of lately is, what do I do when a patient has passed and relatives come looking for information, and making sure that I'm dotting the I's and crossing the T's properly to deal with PHI, because HIPAA still applies even though they're deceased. It just alters who can ask for the records. And then surveys, that's an ongoing issue for us. You see a lot of issues with the surveys coming out. We have a lot of administrative issues. Is the administrator maintaining control? Is the administrator in control? Do we have related entities? Are we meeting? Is our staff, things of that nature? And then that gets into more just general patient care issues of how we're documenting the care. Does our documentation show? Because one of the most common things I see across the board in home care is we get comfortable with our patients. We get to know them, we see them, and then what happens is we stop writing stuff down because we know the patient. Oh, that's Mrs. Smith. The problem for that is, if you don't write it down, it didn't happen. And
Yeah.
you might know the patient, you might have a good relationship with the patient, but what if you're not there? Or heaven forbid, what if something happens to you? If you're in the hospital, if you've not written stuff down on the patient, how do we care for the patient? How do we know what's going on with the patient? How do your colleagues fill in with the patient? And when the surveyors show up, or auditors or investigators, they're all going to look at that. They're not going to give you the benefit of the doubt. They're just going to see gaps in the documentation, or they're going to see documentation where every visit looks the same. So we got to be careful when we're documenting that we're writing down what happens, that we're writing it down as we're documenting contemporaneously with the care, and we're not, falling into that habit of, because we know the patient, we're comfortable with the patient, we're just, jotting down a couple notes and moving on, because we may know it. I've had that come in audits where I'd go to the nurse and I don't understand why this patient's getting health care or home care. What's going on here? Well, the nurse starts saying all the stuff that's going on the patient that wasn't in the file, and you're like, well, we really need to write that down. Right?
Yeah.
I'm asking questions because I'm your attorney, but the auditors aren't going to ask, the surveyors aren't going to ask. They're just going to assume you've done something wrong.
Yeah, everything should be documented. Yeah, should be a record, should be there. And how can agencies effectively develop and maintain documentation practices to meet audit standards and minimize potential liabilities? I think you discussed a little bit about that. Anything more you want to add on that?
Yeah, I think one, obviously know the standards. So you've got Medicare and Medicaid survey standards because they're going to survey you to the COPs, document to the COPs. But then you've got your payer standards. And what What do I have to document for eligibility? What do I have to document to support the codes I'm using? What am I documenting to support medical necessity? If a longer length of care patient, why is this patient still getting care? Why have goals not been met? Maybe goals aren't going to be met. Maybe this is going to be a long-term custodial patient.
Got it.
But then I like to tell folks, you got to remind your staff that documentation is not just about the agency, it's about the individual. So a lot of our staff, we have nurses, we have therapists, they're all licensed professionals. And if you go in every state I've looked at, if you look at the professional licensing standards, they'll speak to documentation. And you can, and I've actually done presentations at state associations. We've talked about the personal risk to licensed professionals about failing to document properly. Or, sometimes our staff get, another thing to hammer on our staff is they get in a hurry and we're trying to get stuff done and they're not, and this comes up a lot. I've seen this, with the EMR, you go in there and it timestamps the entry and you're like, well, it's interesting that Mr. Smith signed this note at 3:00 in the morning.
Yeah.
I'm fairly certain you weren't in there. Well, they were in the home, they're taking notes on a sheet of paper, and then they go home to document because they're trying to get through all their visits.
Uh-huh.
And I appreciate the workload, but that's a problem. Right? If I'm documenting later, maybe my documentation is still accurate, but then you go back to HIPAA, and I don't think the providers think about that notebook that you're writing stuff down in the patient's home to take home with you. That's full of HIPAA. Did you dispose of that notebook properly? Did you shred it when you were done? Probably not. It's probably got, you flip 5 pages in, it's probably got your grocery list in it. It's got other stuff. You use it for all kinds of stuff. So it's really important to educate staff and to re-educate them, and both on the standards, what we're trying to document to, what the records should look like, but also that for our licensed professionals, this isn't just about the agency, it's about your personal professional license. You've worked hard to get this license. And I've had cases where I've had surveyors make nursing complaints against nurses due to things that happened during a survey. So you want to be sure you're documenting it, because you might find you're responding to a nursing board complaint or therapy board complaint because some surveyor or auditor or somebody else gets upset about something they saw in the documentation. And I don't think our staff thinks about that. I think we need to remind them that they have a dog in this fight, and they need to be, there's a personal risk for them that they need to be thinking about.
Definitely. And that does cover most of the things about the next query, that what proactive steps can agencies take to prepare staff for audits? And are there any specific trainings or protocols that you recommend for that?
Well, I'd like to look at like the documentation, like a classic example of home health. We're documenting in a home health for Medicare, we got to show homebound status. And the thing I see all the time is leaving the home is a severe and taxing effort. Like that has been the magic words for home health, homebound status for as long as I've been doing this. But if you actually go look in the Medicare benefit policy manual, it's essentially a 3-part test. Now, severe and taxing effort is part of that essentially, but there's other things that you document. And so I think, you go to that excerpt from the benefit policy and you educate them. Hey, don't forget, these are the elements. For hospice, for terminal illness, there are LCDs, and there are LCDs for home health. You go through those. This is what the MAC has said they're looking for in the documentation. So let's go over this. Let's be sure we're documenting to those standards. Do audits, right? And then when you find problems, you can do insert. Hey, we've been doing some audits, and we notice these things are lacking. We're missing these details, or we're noticing that the notes are fitting a pattern. You see this in the EMRs, or there's checkbox and things like that, where the staff gets kind of like, I have a daughter who's in her 2nd year of nursing now, and I remember when she was doing clinicals, she came home one day and she was discussing this nurse she shadowed who was copying and pasting. She copied the last entry and put in the next entry. Well, in this particular, she was in a hospital setting. The patient, according to the notes that nurse had copied, had trach care. But the patient's trach had been removed 3 weeks ago, but the nurse just kept cutting and pasting. And so, right, it's easy. We're in a hurry. We're not looking at, we're cutting and pasting. Yeah. And I told my daughter, I said, look, I can't emphasize to you enough. Don't ever do that.
Yeah.
If I ever find out you've done that, you're going to be in trouble with me, not the nursing board. And so our staff, there may be steps within the software we can do to limit their ability to cut and paste and things like that. But we need to remind them, look, that's not how we document. So educate that. And when we have audits, when the audit findings come back, the auditors are going to tell you things you've done wrong. Go back to the staff. educate, and then you're going to repeat the education. Like I tell clients, you can't just tell your staff once. So there's some baseline stuff. What's it mean to document homebound status? What's it mean to document a visit properly? What's it mean to document, medical necessity? All the things we need to write down. We're going to go over that again and again. Maybe we're sending emails with reminders. Maybe it's an in-service. There's other training components you can get through various companies where you can do other types of online training. But I really think it's important to train, and train again, because the staff will forget. And then as we find gaps, as we find problems, as we identify things through surveys and audits, that we then train on those gaps. We identify the problem, we fix the problem, and then we train on that to make sure, hey, the surveyor identified we did this wrong, got to fix it. Here's how. It's an ongoing process. Because the other thing too is standards will change, guidance change. Like we just got the new home health survey guidance this year from CMS.
Yeah.
And so that changes how we do things. And so we got to go back and tell the staff, okay, we did it this way for the last 10 years, but now CMS wants it done this way. So this is how we're going to do it. And then we train, and train again. Training is, I think, an area that we have so many things to train about. And we sometimes overlook documentation, I think, because you have a limited number of things you can train about every year. But I do think when you really focus on that and make sure we're hitting those key elements and reminding folks, especially avoiding shortcuts and things like that, because those are things I see providers get in trouble for.
Yeah. And lastly, in case of adverse audit findings, what options do agencies have for appealing, and how can they better position themselves for a successful appeal? Your pointers on that.
So, and this is something I've been doing a lot lately. The home health and hospice audits have been on the uptick for several years. So, step one, right, when you have the audit, what I tell clients, usually where we start in preparing for audit results, you get the request for documents from the auditor, you submit those documents. We always keep a copy for ourselves. Then I recommend at that point we bring in a third party consulting company to audit the records as well, to find out what are we looking at. Is it good? Is it bad? Often, the third party auditor might actually grade you more harshly than the MAC or the SMRC, because what their auditors are going to do, they've got a huge caseload. They're going to find the first thing they can find to disqualify the record. That's all they're going to look at. Okay, homebound status not supported, face-to-face documentation missing. They'll look at the rest, and then they'll add that to the pile of, okay, bad claim. But if we have the auditor comes in, they look at it. We'll have a report in advance. So we'll look at, here are our deficiencies. Here's what we need to argue. Here are the potential defenses we have, the claims we can and can't fight. Then you get the demand letter. Usually you get an audit result first. Like if you get a UPIC audit, the UPIC sends you a letter, says, here's what we found. That's not technically your demand. You will get a demand from the MAC saying, okay, you've been audited. Here are the claims that are in error. Here's what you owe the government. That's when the clock starts. And now you've got, a time frame to get your appeal filed. And the key there is if you get the appeal filed quickly, they won't start recouping. Because if you don't appeal, they'll begin to recoup your dollars. And so what'll happen there is they'll basically hold 100% of your reimbursement until the overpayment has been paid. If you get the appeal filed within 30 days of the letter, that prevents recoupment at the first level. So you'll prepare your response and you'll submit it. You have longer than 30 days to submit it. And if you submit later than 30 days, the recoupment might start, but it should stop upon submission of your appeal.
The best is before 30 days.
Yeah, do it. And that's where, having done the audit in advance, we're already prepared so we can move quickly to file the appeal. Because it would be shocking to me if you get audited and they don't come back and demand money. Now, you might get a load. I've had a couple of clients that the demand comes back and the numbers are so small, like, you know what, let's just pay it. Because there's a cost benefit, right? If you come back and they're demanding $800,000, all of a sudden the cost of litigating makes sense. If they're demanding 5 or 10, that's the point, right? By the time it goes through all the effort of the appeals, because you're going to have to get to the third level before you really see any success. Because the first two levels, the redetermination and the reconsideration, you're basically going back to the same folks that audited you and saying, hey guys, come on, we tried. Can we think about this? Not surprisingly, you don't like. I've had several appeals in the last year, and I was just talking with the consultant on the appeals, trying to recall if any of the claims we appealed got reversed before we got to the ALJ. And I think there was one, and that was one where the intermediate, the quick, which is the second level appeal, reversed it before we even appealed. They're like, oh, wait, hold on, and they dumped it. But otherwise, you got to get to the third level, which is the ALJ, and that's important just to set expectations. Don't be surprised if you are appealing, you lose the first two levels.
Okay.
When you get by the time you get to the third level, the recoupment will have started. The recoupment only lasts through the first two levels. So to get to the ALJ, they're going to start taking your money, and in some cases, you may have already had all the money taken before you get to the ALJ. But at the ALJ level, now you have an independent third party, an administrative law judge, the Office of Medicaid Hearings and Appeals, who's going to look at that claim. And at that level, providers are much more likely, like a 50 or 60% success rate at that level. But it's important to get to that level that at the first two levels, you've made a clear record. So I recommend getting an attorney involved at the beginning, even if maybe you file the appeal yourself, because one thing that's very important at that first level is to make sure you submit all the evidence. And so what I will do at the first level, I submit the entire medical record, even if it's not completely relevant, because that way it's all available later to argue with the ALJ. I had a case once where the client handled the appeal and they misunderstood the issue in the appeal, and they only submitted a handful of documents for each client. And when I got involved at the ALJ level, the problem we had was that the documents they submitted did not respond to the specific issues of the auditor in the original denials. They weren't helpful. So at the ALJ level, you can add evidence, but you have to show good cause. So we filed a petition and explained our good cause for why we're trying to add evidence. Well, not surprisingly, the ALJ is having a large caseload. And the ALJ sees a way to close out a case quickly, because if I'm coming to the ALJ saying, like, I need this evidence to win, the ALJ is like, wait, if I don't let them add the evidence, this case is over. I can close this file and move on to my next one, because they have lots of files.
Got it.
And so not surprisingly, the ALJ didn't let us add evidence, which meant we could not address the specific deficiencies that were the basis of the appeals, because we didn't have the documents in the record, because they had not been submitted at the first level. So it's very important at that first level you get all the documentation in, because when you get to the ALJ, you can't add documentation. It's a de novo review. The ALJ will review everything de novo, which means it's a clean slate. The ALJ doesn't care what the quick ruled or the ruled lower levels. The ALJ makes their own determination, but you have to have the records in evidence for them to make that determination. So let's say your claim was denied for deficient or missing face-to-face, and let's say you had it, but you forgot to submit it. When you get to the ALJ level, if that face-to-face isn't there and the ALJ doesn't find that you have good cause to submit it, it doesn't matter that you had it. It's not in the record, so you'll still lose that claim, even though you actually have the face-to-face, because you didn't submit it at the first level. So when you get that demand, it's worth reaching out to an attorney who understands. And I'm not saying this to create work for myself or other attorneys, but it is a good idea to talk to an attorney about the process and getting them involved. Even if you think you can write the initial two levels of appeal yourself, to make sure that you're getting guidance to make sure you have all the right evidence in place. And I've got a couple consultants I work with where it's not cost effective for me to get involved to get to the ALJ, but I'll look at it and say, well, here's some arguments to raise. And the consultant will just add those into the boilerplate letter they submit, make sure they've got all the evidence. Like, here's the records we should have. Then they do the rest. And then I know when I come to the ALJ level, I know what was submitted at the first level. I know we submitted the entire medical record for the patient. So I have all the evidence I need to make whatever arguments I want to make with the ALJ, as opposed to showing up later and like, oh, wait, we missed this document or that document, and the judge won't let us enter it. So that's very important to talk to counsel early on to make sure that you have those records, because if you don't, then you won't be able to make a claim. And the other thing too is to make sure that when you get the demand, you calendar your deadlines, because if you miss a filing deadline, either at any level, if you're late, the appeal's over and there's nothing you can do about it. So I've had clients where they've reached out to me and say, hey, we need help with this appeal. I'm like, sure, send me the documents. And so I send the demand letter over and I look at it. I'm like, you guys got this 6 months ago. Like, well, yeah, we were talking to the MAC, about the appeal, and maybe we could work some of this out. And there's an option in the letter. It'll tell you there's a dispute resolution process. And so they had talked to the MAC, and not surprisingly, the MAC kept talking to them. And then so the appeal deadline is like 180 days. On day 181, the MAC's like, well, we're not going to talk anymore. We want to keep the money. Well, at that point, they knew they were running the clock out, right? It's
Got it.
like
Got
watching a
it.
football game. They're the clock's ticking down. Like we just got to
Yeah.
get to the end of got to get the final whistle. And so they came to me and I said, I can't help you. I said, this
Mhm.
appeal needs to be filed 2 days ago, and there's nothing I can do to resurrect it. It's an absolute bar to the claim. So you've got to be very careful to understand if you get that demand letter, there's an appeal deadline. If you don't formally file an appeal, talking to the MAC doesn't matter. If you don't formally file the appeal per the procedure outlined in the letter, then you will no longer have a right to appeal, and the likelihood of getting that overturned later is very low. It's an absolute bar to the claim. So I always tell clients you've got to be very aware of those deadlines and be sure you don't miss them. Because when you call me the day after the deadline passed, I'm like, this is it's a
You
sad
won't be
story.
able
I
to help
appreciate
them.
your frustration, but I don't have a time machine, and so I can't help you.
Got it.
That's
Got
a
it.
really
Okay.
important one. You have your documents, don't miss your deadlines. That's the two biggest things with those appeals.
So timeline is pretty important.
Yeah.
Okay, 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 okay. All right. So thank you. Thanks a lot, Robert, for sharing your expertise today. And to our lovely audience, thank you for tuning in. Until next time, I'm Dennis Gill signing off. Have a good one, everybody.